Thank you all for coming, and let me start by introducing our wonderful panelists who we also thank for coming here today. Starting at my far right is Steve D'Alessandro. He is the co-head of the Government Investigations and Regulatory Enforcement Group in the legal department at JPMorgan Chase. Prior to joining JPMorgan in 2013, he was a partner at the law firm Holland & Knight, where he represented companies and individuals in criminal matters and conducted internal investigations. Before private practice, Steve was an assistant U.S. attorney in the criminal division in the U.S. Attorney's Office in the Eastern District of New York here in Brooklyn. Immediately to his left is Glenn Leon. Glenn is Senior Vice President and Chief Ethics and Compliance Officer for Hewlett Packard Enterprise. He oversees the strategy and implementation of HPE's ethics and compliance program, which includes ethical decision-making based on the company's standards of business conduct, and also both internal and external investigations. His team's responsible for social and environmental sustainability and compliance, global trade, and privacy. Prior to being at HPE, Glenn was a deputy chief of the fraud section at the criminal division of the U.S. Department of Justice, where he led investigations involving securities fraud, FCPA violations, bank and mortgage fraud, and other matters. Before that, he was an AUSA in the District of Columbia for 12 years, and before that, he was a litigation associate at 2 private law firms. One seat closer to me is Anne Claire Phillips. Anne Claire is Senior Vice President at U.S. Bank and serves as the bank's Chief Government Investigations Counsel and Chief Legal Risk Officer. She previously was also an Assistant U.S. Attorney in Charlotte, North Carolina, and also in Louisville, Kentucky, for a total of 10 years, during which time she prosecuted complex financial crimes, narcotics trafficking, and associated violent crimes. She was detailed to Iraq to co-direct the Department of Justice investigation into the Mahmoudiya rape and killings, which resulted in the first federal case indicted under the Military Extraterritorial Jurisdiction Act. Before that, she spent 5 years in private practice as a corporate litigation associate and 4 years of active duty as an assistant staff judge advocate in the U.S. Air Force Judge Advocate General's Department. Immediately next to me is my partner, Katja Jestin. She is a co-chair of Jenner & Block's Investigations, Compliance, and Defense Practice. Katja counsels companies and individuals and executives in criminal, regulatory, and congressional investigations and represents clients before the Department of Justice, the SEC, and the United States Senate. She does internal investigations on behalf of corporate clients, provides counsel to senior management on criminal, regulatory, and other compliance issues. Katja played a lead role in the investigation and resolution of the United Airlines matter in the District of New Jersey, or with the District of New Jersey, which resulted in a non-prosecution agreement, and also has played leading roles in our firm's work on a variety of other matters, including the GM investigation, a major mortgage fraud matter, the representation of a major law firm that resulted in no charges, and other matters. Katja was at AUSA also in the Eastern District of New York, U.S. Attorney's Office, for about 7 years before joining Jenner & Block. And briefly, I am also a co-chair of Jenner & Block's investigations practice with a background similar to Katja's. I was a team leader in our GM investigation and co-lead the Credit Suisse monitorship that we conduct. And I was an AUSA in the Southern District of New York, in DC with Glenn, and also worked at Main Justice. So together here we have a panel that has seen, experienced, created perhaps corporate crises, and I think that it's a well-situated group to talk to you all about how you address and how you might address if this were ever to come to pass in your experience at your companies, because it's potentially an existential crisis situation. It's certainly a very threatening one, and it's also very different than a lot of the things that many of you, if you haven't experienced something like this before, it's very different than a lot of the other work that you might encounter, even including litigation matters. So why don't we start the discussion with our in-house panelists and basically posit a hypothetical here. And why don't we start with Anne Claire? let's say that you get a call that the company has gotten a grand jury subpoena from your local or some other U.S. attorney's office, and then you get a phone call from a panicked executive, a high-ranking executive, that they have themselves personally also received a grand jury subpoena. What's the first thing that you do, Anne-Claire? Who might you call in the company? How do you figure out what's going on?
Sure. I think the first thing you do is have everyone remain calm. This is a scary event for any company. For all of us as former AUSAs, we issued grand jury subpoenas. That's just a regular thing. But for most companies, this is not a normal day. And what you want to do is have everyone take a deep breath, get a grip on the situation, and don't just react. You want to try to find out some facts, and I guess have folks, not circulate this too much until you can get the lay of the land.
Great. Glenn, can you add to that? Who might you start working with inside your company before you go outside? What are some of the steps that you might take in terms of who you might call, some of these investigative steps that Anne-Claire referenced, or anything else that you might do right at the beginning?
Sure. So internally, I would certainly report it to my boss, who's a lawyer, chief lawyer for the company, and start there. It's a good place to start. And depending on the nature and just kind of an initial assessment, we can probably figure out, is this going to potentially hit the press? Is this going to have a customer impact? Just try to get a sense in the first few minutes and hours, is this a big, medium, very big thing? And what may happen in the next 24 hours? And that will help inform who else we let know within the company. So let the CEO know. I think that's probably, in all likelihood, something we would do. Probably not let the board know, but we might have to. But based on this hypo, something we'd want to make sure the senior leaders of the company know. And then the other internal stakeholders, I'd say we would reach out to, corporate affairs. Want to make sure that they're aware from a comm standpoint, communications. If this does get any press attention, we want to make sure that they understand what it is, what we know, what we don't, and that we are all speaking with one voice until we can, as Anne-Claire says, just figure out what we're dealing with. So yeah, just trying to make sure we are speaking with a consistent voice and making sure we get the right stakeholders involved.
So Steve, both Glenn and Anne-Claire talked about kind of figuring out what's going on. How do you figure out what this is all about? What kind of steps do you take to figure out whether it's a small, medium, or large problem, or what you do next?
So I think everybody has benefited from Google. It's an amazing source to learn information. You can quickly identify if there's media stories, if there's some news event, if there's something in a public filing by a different company that may be related. One of the simplest things to do, which is high on the list, is just pick up the phone and call and find out, are the people that you want to introduce yourself. You want to try and maintain some point of contact so that if there are going to be future subpoenas, that they're coming to the legal department. They're not just being sent all around, so that you could potentially have inconsistent responses or frustrate the government in a lack of timely response. But in that conversation, in that introduction, you can ask questions about the nature of it. They may not share it, but a grand jury subpoena doesn't mean that the person is a subject or a target of the investigation. They may just be a witness. And your institution may simply be a fact witness. And so, I tend to try to get smart as much as I can before I'm picking up the phone, because all the questions that you would have, the person that I'm going to call is going to have. And there's some limitations on what you're likely going to know, especially in the circumstances of a grand jury subpoena. But those are some first steps you'd probably want to be thinking about.
And in terms of other kinds of first steps, what kinds of things, Glenn, might you do to, say, preserve documents? How do you decide how to preserve documents, what kind of systems that you need to preserve them at, and really what kind of things you need to freeze as the way it exists now, so that you don't create new problems?
Sure. Very basic starting point is you read the subpoena carefully, or the subpoenas carefully. Prosecutors tend to write subpoenas fairly broadly, but still, if they're written for a particular investigation, they will give you a lot of clues as to what you're dealing with. Is it a particular region, particular business unit, particular time period, particular individual's name. So usually just starting with the subpoena or the subpoenas will give you a lot of your most obvious places to start and then start preserving. And then mechanically, we've got a system in place where we can, within receipt of the subpoena and then reading it carefully, we can reach out to our partners within the company, within cybersecurity, on the investigations team, which rolls up to me, to start preserving right away in basically real time.
And why is it important to do that? Why is it important to preserve things in real time in this kind of situation?
For several reasons. One is you need, one of the many things you need is information, and the information is largely in emails and documents. So you want to make sure you have the ability to learn what's going on, to tell your story internally and ultimately, in all likelihood, externally. And then the more, the broader reason is there are certain clear implications if people sometimes inadvertently will delete documents, so as opposed to, in the worst case scenario, intentionally delete documents. We don't see that, but there certainly could just be an instance where people just aren't preserving documents. We have a large company where people come and go a lot. So sometimes if you don't, it may involve some people who have been terminated or leave the company. We have a policy where documents are retained for a certain period of time, but then after they leave, their laptops and their electronic information is not necessarily preserved. So the quicker you can just preserve it, the quicker you can prevent any suggestion or implication that you're not fully cooperating with the government.
So let's say that it comes to one of your companies or one of yours, and you do this, you scrutinize the grand jury subpoena, you freeze the documents, you stop automatic document deletion, you issue a document retention notice, you kind of figure out what's going on, and what you learn is this falls into Glenn's bucket of big problem, or even medium problem. I mean, even a small problem can be a big problem. But let's say, by any definition, what we have here is a big problem. So, Anne-Claire, how do you decide at this point that you've found this big problem, you've done a little bit of initial fact gathering, you've frozen as much as you can, how do you decide at this point whether you're going to kind of keep the investigation in-house and do it yourself or with your own team, or whether you're going to go outside to a law firm or multiple law firms to help you do this work?
Sure, there are a number of things I would look at. They range from what's the topic of the subpoena, what business line is this a hot area in the industry? Like Steve said, you can do a quick Google search and get a sense, is this something affecting everyone or is this unique? I'd want to look and see where the subpoena came from. Is it one of the heavy hitter agencies, so to speak, the DOJ or the SEC, or is it more of an outlier or a regulatory type of matter? I would also want to see what district it came from, and really, again, just kind of get that lay of the land. My inclination would be to bring in outside counsel. Like if you said, if it's something major, we're going to want someone on the outside. We're going to want folks experienced in this area. But before you can do that, you need to know a little more. You have to have something when you call these outside firms to tell them, we received a subpoena and this is the direction we think it's going.
So aside from obviously calling Jenner and Block first, Glenn, how might you pick your outside law firm in this kind of a situation? Right. This may really just be a question for the outside lawyers really want to hear this, but anyway, yeah. Well,
I want to add a fourth bucket, which is there may be no problem at all. Like I said, big, middle. Okay. So it could just be we're a victim, or it's a true investigation. So you really need to have the range, but we're dealing with a medium to big problem. Okay. It sounds like here. Okay. It depends. We have a lot of people in-house with a DOJ background, not just myself, but a number of other people. My head of investigations has a strong background. He's a former prosecutor. We have other people. So we will do a lot of that initial assessment ourselves. But to your question, who do we choose and how do we choose? We actually, we have preferred firms, and they're there for key strategic reasons. But in a case like this, we'll probably get very specific. We might well micro-target. To your point, if it's a particular district, we may want to really think about people with a particular relationship with that district. If it's DOJ, that's different than maybe somebody who works at the SECs. If it's something that may have, I work at a global company. It could be something that has implications abroad with another country. It could have implications that may touch on cybersecurity. So really, when we get to know it, if we think it's a big problem, we're going to not necessarily reach out to that top firm that's our key firm. We might, and we may start there, but we're really going to micro-target to really make sure that we partner with the people who have the relationships, who really have the real expertise to help us really figure this out. Because a lot of it is going to come down to just those kind of idiosyncratic things about knowing the office, knowing how to read the tea leaves.
So we're really talking at this point still about what happens at the very beginning. And so, Steve, I want to ask you a question about something that is an issue at the very beginning, but also, and we're going to stick at the beginning for a little while, but also if you could tell us a little bit how you keep an eye on this topic going forward. And this is, I'm sure, is a topic of interest to a lot of you. How do you make sure that whatever outside counsel you do bring on stays within the scope of what you want them to do and doesn't, how do you balance the issues about scope? Clearly, you want them to be comprehensive and do a good job, but at the same time, you don't want to give them carte blanche to, spend whatever they want to spend. So how do you do that?
Communication, right, and engagement. So, we stay very much involved. I mean, just because outside counsel's involved, it doesn't mean that anyone, on the legal team is able to free up their schedule and now is going golfing. It's quite the opposite, right? The matter, it's your matter. It remains your matter. You have the assistance of outside counsel. What I think is sometimes missed is the role of the in-house counsel in those situations. They become, outside counsel becomes part of the legal team, and you need to stay abreast and communicate. And look, scope changes. Right? You get a request in and you think you figured it out and it changes 2 minutes later. And so that level of engagement and communication and keeping that open throughout gives you the flexibility so that you can pivot at important times to expand or contract the matter. But that means, communication means both communications within the team, but also with your client and the partners with, your key stakeholders within the institution, so they understand, because, the focus, right, could be over here, but we see a collateral issue not related to what the government's thinking about, but there may be a certain risk issue that we've identified that we want to explore, right? So those are the types of things that we're constantly, it doesn't necessarily go to scope per se as it relates to the matter, but it all comes down to those two words.
Okay, so Katya, let's say that you are the lucky recipient of one of the calls from one of our panelists about this unlucky situation. What do you do when you get that call, and what do you do at the outset of this kind of crisis situation, whether it's small, medium, or large? I guess everyone hopes that you do the initial look and it turns out to be nothing. But let's say you get that call and you're being brought in. What do you do?
So I think one of the most critical initial questions is scope as it stands at that moment. So in your hypo, you mentioned that a chief executive had also received a grand jury subpoena. So I think one of the first issues I would really want to try and understand as quickly as possible is why. And if there is involvement of somebody at the higher reaches of the company, you really have to be very careful in designing your team that you're going to work with in-house to address this investigation, and to make sure that nobody on your team, nobody who you're reporting to or who is within the structure was involved in the facts at issue that provide the underlying basis for this grand jury subpoena. I think that is one of the most critical frontline issues you have to deal with. Obviously, you have to make sure all the hygiene issues are taken care of, the document hold has gone out, it's correctly drafted, it's broad enough or narrow enough, the automatic delete function has been turned off. All of those hygiene things are very, very important, because as you proceed through your investigation, one of the most critical features of your work is that it's trusted both by your client and trusted by the government. So you just want to make sure that your hygiene is taken care of appropriately, and that the circle of trust that is developed within the company is it's comprised of the right people. So I think in your hypo, that would be my first question, and I would really want to drill down on that initially and maybe do some scoping, factual interviews, and kind of figure out what the metes and bounds of the issue are at that point. And then I think the next critical question, given that your executive has received a grand jury subpoena, is whether that executive has exposure. And obviously that is a question that is going to develop and evolve over time as you learn more facts. But this may be a situation where you want to find a lawyer for that executive, and think about getting an independent legal advisor. And I think we're going to get into this. There are a million issues that surround that, and it's a complex area of our practice. But given the receipt of a grand jury subpoena by that executive, that may be a best practice in this situation.
Why don't we get into that a little bit now, since the hypothetical, since you've touched on it, and the hypothetical involves a subpoena to a senior executive. I mean, presumably, in any of these situations, the senior executive might have gotten one, but also some junior people in the company may have. People at other companies may have, which you may or may not know about, and you'll try to figure that one out as well. How do you assess the question, Katya, why don't we start with you. How do you assess the question, and obviously you work with in-house counsel as well on this, but how do you assess the question of whether you bring in outside counsel for individuals, or whether you as the outside lawyer representing the company might represent these individuals, or whether you might adopt some kind of hybrid where you represent some and outside lawyers represent others? What are the issues you look at, and how does it break down kind of in practical terms?
So I think this is one area where criminal practice is sharply different from civil litigation. I think when you are dealing with a criminal grand jury subpoena, this is something that requires a lot of attention and care. I generally think it is not a good idea for counsel to the company to also represent individuals in the company jointly in these situations. One of the main reasons for that is that, as we've kind of touched on here, the facts evolve. Every time you start an investigation, you have one version of facts in your head, and as you dig in, they ultimately and inevitably change somewhat. If they change somewhat in a way that presents some sort of conflict of interest between you and an employee who you've decided to represent jointly, you've just put a huge red flag on that employee for the government. Once they see someone gets new counsel, they're going to know that there's a reason for that. And so you've put a target on their back. That's not a good thing. And I think there are other reasons, just generally speaking, that it's just not considered a best practice in the world of grand jury subpoenas, as opposed to in civil litigation, where it may be just fine. So upon the receipt of a grand jury subpoena, when I'm representing the company, any individual recipients of a grand jury subpoena, I would want to look at first in kind of the first tranche. And I would want to think about and try to analyze the facts underlying why they were picked by the government to be recipients of these subpoenas. It may be that each of them needs his or her own lawyer. You want to pick lawyers who you can recommend to your employees, who you know, who you trust, and who you think will have credibility with the government. And then you may decide that certain of your employees, just to help ease the process for them, if it looks like ultimately they're going to be interviewed by the government, and this is obviously kind of jumping ahead as you've proceeded and matriculated through this process, you may want to get them pool counsel, and that's something we should, I think, talk about here, because there are issues with that are interesting and can be complex. But if you think about an employee who's going to be interviewed by the government, and what you want to do for that employee and what's in your company's interest, many times that is have that employee represented by a lawyer, not you. That employee will have the benefit of being prepared, have the benefit of having their recollection refreshed through documents, and have someone at their side in the government interview to just look out for their interests and make them feel more comfortable. And on the other side, and this is a little counterintuitive in my experience, the government really appreciates that. They like a prepared witness. They like a witness who has a credible white-collar practitioner by their side who can help guide them through the process. So it actually, I think, works out well for both sides. But those are some of the initial questions I would think about.
So still on this question of counsel for individuals, Anne-Claire, let me just define some terms just to make sure everyone is clear on this. So we've got individual counsel, Katya talked about that, where each individual might get their own lawyer, or we have pool counsel where one lawyer might represent a group of people, and it really could be a large group of people. I mean, we've seen it as large as 50, 70, one lawyer. More commonly, it would be a smaller group, maybe 10, depends on the scope of the investigation, or maybe there's multiple pools. So Anne-Claire, can you talk a little bit about some of the issues that Katya raised, and also, in particular, this question of what the pros and cons might be of bringing in pool counsel or individual counsel or outside counsel? Like, how do you analyze these questions in-house and sound into your outside lawyers, if they're involved, about what you want them to do?
I agree with a lot of what Katya said. I mean, these are important decisions, and they're decisions that once they're made, it's very hard to unwind them. So you need to be thoughtful. With regard to pool counsel, in the right situation, that can be a really good option for a company. There are a lot of benefits there. Obviously, there's a cost benefit if you're paying one law firm versus paying 50 in your example. But even beyond that, there are efficiencies. It takes time for outside counsel to get up to speed, to meet the witnesses, to review all of the documents, and to become familiar with the matter. And certainly if you have pool counsel and they've done this once, it's going to make things much more efficient going forward for the other witnesses. That's something that the government likes. It doesn't hold up the investigation, and that tends to reflect well on the company. Having said that, there are times pool counsel isn't appropriate. There are times where you're going to have a conflict of interest, or a lot of times there may be a conflict of interest. There may be some optics there that it's not a good idea to have these multiple witnesses all represented by the same firm. And in that situation, in my experience, we would err on the side of caution and bring in multiple lawyers.
Okay. So let's step away from counsel a little bit and come back to the company and what the options, the menu options might be strategically for the company in terms of, let's make this a DOJ investigation. Okay, so it's the biggest stick out there, really, in this realm, maybe the biggest crisis that can actually happen in this realm. And what's the range of options for a company when confronted with a Department of Justice investigation? What are your choices, Glenn?
In terms of just how to deal with the DOJ?
Yeah.
So the range could be you kind of hunker down and you get an aggressive defense attorney or criminal counsel, and you slow walk the prosecutors and you just kind of fight on things and kind of on that extreme, all the way through various levels of cooperation, all the way through extreme cooperation. I mean, there are some companies that waive privilege and go to all sorts of extremes on cooperation. My company, I think most companies don't take that first approach. My company has a strong culture, and I'm sure just probably every company in this room has a strong culture of cooperation, but it is situational. I think you want to know, you're starting out in a position of imbalance. You're checking out on Google. You're talking. You're preserving documents. Those first few hours and days, you really don't know what the government knows, and you want to cooperate, but you also need to make sure you speak with clarity. You speak the truth. To a point Katya made, that your credibility is everything with the government, and if you screw that up early, it's nearly impossible to correct that. You can, but we could talk about that, but it's hard. So when you speak and interact with the government, you've got to make sure you're telling the truth. And the truth could be, you've asked a bunch of questions. We can tell you the answers to these two. These four, we just don't know right now, but we're going to get back to you by middle of next week. In the meantime, this is what we're going to do. We're going to do this. We're going to preserve these. So you can be very transparent and communicate a lot, even if you're telling the government, we don't really have much to tell you substantively. That is a form of cooperation. So I think in those early stages, my strong recommendation, our practice is certainly you want to cooperate, but you don't want to overpromise, and you certainly don't want to say anything that's not true. I've seen situations when I was a prosecutor where defense attorneys or corporate counsel come in and just say things that just aren't true. And I don't think they're necessarily lying. I think they may be spinning, or they may be not as informed, or they may not know as much as the associate or junior partner behind them. There could be all sorts of reasons. So I do think that you want to be as truthful and cooperative as you can, but you've got to do so responsibly.
Can I add something
Yes,
too?
please.
I think you raise a really good point, because that kind of initial contact with your corporate client, in addition to kind of figuring out the lay of the land as quickly as possible, I do think there's something to putting kind of a measure of control over the corporate functions, which would include PR and statement making. And we've seen, and I don't need to name companies, but we've seen time and again statements of denial or a more spin-like statement being made in the early days, and that having a reverberating negative effect on the ultimate resolution with DOJ. And I just cannot emphasize enough how critical it is to avoid that and to say nothing, or to say something that is neutral on the facts and that can never be misread or interpreted by DOJ as a denial or somehow lacking some measure of contrition or ethical culture.
And just to build on that exact point, the other stakeholder here are clients and customers. They may read something and they may have all sorts of questions. Hey, what's this? I just saw this. I'm getting questions, and they reach out to their business partner, who's not a lawyer, who doesn't know what's going on, and whose inclination is to say the right thing to sue the customer. So you want to get that comms, the communication, in all levels of the company, including to the business partners who can, because can know what to do and say responsibly, but again, with one voice.
And I think, kind of to a point you made earlier, these things don't happen very often in large companies, especially companies like the ones here today that have a strong ethical culture. This is an unusual occurrence in the big example that Tony's mentioned. And so I think people unwittingly may take steps that they feel are appropriate because it is about brand protection or brand management, and they don't realize that the impact on a DOJ investigation can actually be very negative. So it really is important to send the message out. It's, this has to funnel to one place in the company. This is where the power over this particular investigation rests, and there's no independent action going on. This has to be here and discussed in this room with these people before anything's said or done.
So I just want to give a few facts or statistics for context, and then Katya, have you maybe explain a little bit why we see this. So just to take 1 year, for example, in 2015, only 4 companies, according to the statistics that we gathered and that are available for the federal system, only 4 companies went to trial in 2015. And 98% of the companies that were charged either pleaded guilty or entered into a non-prosecution or deferred prosecution agreement. So those numbers, for those of you who don't do this, are really perfectly consistent with the federal system and the criminal justice system as a whole, where 97% of individuals plead guilty. But I guess the point is it's not different for companies. Why, Katya, in this corporate context in particular, and maybe even more generally, why is it that no one fights? Like Glenn said, the first possibility is that, but his company doesn't do it that much. Part of it is cooperative culture, good culture. But what else is there about the law and about the system that makes it so you can't do that in most instances as a company?
So I would say that it's just not a fight typically worth having, because at the end of the day, I think if you are a company and you have shareholders, or even if you don't have shareholders, your reputation is the coin of the realm. And if you decide to have a fist fight with DOJ and go to trial, what you've put at stake reputationally many times is just something that's just not worth the risk. So companies that do have ethical cultures, I think, try to look at this process, and this sounds, it's a difficult pill to swallow, but to try to be as positive about it as possible and look at it as something to get through and emerge stronger, not emerge weaker. And I think if you engage in a fistfight with DOJ and it's in the newspaper every single day and witnesses are testifying about terrible things that happened at the company, many times that's just too high of a risk to bear, and it's just not worth the collateral consequences of doing that. So instead, the approach can be cooperate fully, work with DOJ, and emerge stronger. Fix whatever problem in your compliance function didn't function properly in this, to allow this to happen. And just trying to look at it that way and look at it as an opportunity to emerge stronger and better and get out with as low a fine as possible if that's what happens, an MPA or a DPA versus a criminal charge. Just on the menu of options, you want to get out as quickly and as unscathed as possible, and trial is usually not the way to do that.
And let's take a situation where you've got one or a small group of employees who might have engaged in misconduct, but it's not a corporate-wide problem. Can you tell us briefly, just so everyone's on the same page, what respondeat superior liability is and what other kinds of ways a company can be held responsible in a criminal context for the actions of really rogue employees?
So in our system, a company is liable for the misconduct of its employees, even if it's a very low-level employee, so long as the conduct was taken in the context of their employment and the company somehow benefited from it a little bit. It's a very generous standard of corporate criminal liability. So you could have a very low-level person in your back office who has been committing some sort of fraud and has been pocketing some of the proceeds, but the company can be described as having benefited from it a little bit, and the company can be liable for that violation and could be criminally charged for it. So it is a very generous standard, and so it creates a lot of exposure risk for companies, and that's generally why going to trial from just a pure proof perspective is not very appetizing.
Okay. So the hypothetical that I've posed so far has been the Department of Justice, but let's bring in the possibility of other actors at the same time, or well, really at the same time to make it more complicated. So let's say the SEC is involved, maybe Congress, state attorneys general, just the whole menu of horribles of people trying to get a piece of the action, get a piece of the settlement, get a piece of the media coverage, et cetera. So Steve, how do you balance this kind of a situation where you've got multiple enforcers, multiple agencies, multiple government bodies investigating the same or related sets of conduct? Like, what do you do? How do you prioritize, and how do you balance and handle this multiple point onslaught?
Well, it never happens because they all coordinate.
They're all
It's
very well
coordinated
coordinated,
very
right?
well. The truth of it is, and the reality why that happens is because there are multiple regulators, there's multiple enforcement authorities, they have their own mandate, and they perhaps are made aware of facts that they believe is within their jurisdiction, and they want to get those facts. And so if you sort of approach it in that way, the answer is quite simple. You need to get them the information that they're asking for. The challenge really becomes if you're having competing priorities and understanding how you're going to try to address all those. The simplest path forward is to try to get all the parties together as you're sort of moving forward so that you can have the types of conversations Glenn was talking about with transparency, having them understand the process you're following. There may be some challenges, right, with grand jury information. If the SEC is involved or some other, there's sort of restrictions. That's their problem, not necessarily yours. But, we're talking a lot, right, about what we're doing internally. There's another part of this, right, is the government, right? And there's nothing wrong with picking up the phone and sharing with them, where you are. I strongly, support Glenn's notion of transparency. One of the things that you often have to do is get comfortable with I don't know. Get comfortable with I don't know yet, but I'm going to find out and I'll get back to you. That guessing, you will guess wrong. I guarantee you. And as soon as you think you know it, you do not know it. And so it's okay to say I don't know. That is an honest answer. And so when you're dealing with those issues of priorities, I would encourage people to try to have a conversation across, the other side. But also be mindful about being consistent, right? I mean, it seems obvious, but I'll just say it anyways because it's my nature. Like you can't be speaking out of both sides of your mouth, right? The answer is the answer. It's to one regulator or the other. If the facts change and you learn something on that side, you need to go back and make sure that your answer has been consistent throughout. So just making sure that, and if you just start thinking about it at its base as facts, it's an easier way to sort of approach the problem.
So that's a great point about the I don't know, which I think is actually great advice in life, right? Just be willing to say, I don't know, and go figure out what the right answer is. Let me twist that a little bit, though, and Claire, let me pose something to you. Let's say you do know, and it's really bad. So you've done a little bit of digging, you've hired an outside law firm, you've frozen, and people have looked at the documents, and it's really bad. What do you do?
This is the point where, again, you take a step back and you think. You want to be proactive, but you don't want to jump right into it. I mean, if it's bad, there are going to be steps you're going to take. Like you said, that's probably not a situation that you're going to want to go to trial on. So you're going to want to think about, how do we present this to the government in the best light? The facts are the facts. And like Steve said, you can't twist those, you can't spin those, but you can provide context and you can provide color. And for every criminal case, for every regulatory matter, there's a story behind it. And if you can tell that story, if you can educate the government and think about what you're going to say and think about how to explain and maybe present some evidence of how things are different, whether it's remediation or changes in personnel or changes the company's made in its policies, all of those are things that are going to bode very well for you. And I don't know about you guys, but in my 10 years as an AUSA, that was something I really respected, when a company would come in and help present that context to me and let me see, look, this isn't just this isolated event, there's a story behind it.
Katya, can you add a little bit on this in terms of, as outside counsel, making a presentation to the Department of Justice or whatever government agency, how you fit these bad facts into your dialogue with the government to try to resolve a case? And when you have these bad facts, can you still get a good resolution, and how?
So taking your last question first, yes, you can still get a good resolution, for sure. No doubt about it. I think the key is, building on what Anne Claire said, is marrying those terrible facts with the advances that you've made as a company since your discovery of those terrible facts. What did you do about it? I mean, that's really where the rubber meets the road. What improvements to your compliance program did you make? Were people fired? Were your chief executive who received the grand jury subpoena, who was involved in this terrible, massive criminal conduct that's been uncovered, did you claw back some of his compensation? What did you do to make sure that your company will not experience this kind of conduct in the future going forward? And they want to hear something real. They don't want to hear the pleasantries of our tone at the top is great and our this and that. They want to hear real, fact-based, detailed steps that you have taken as a company. So I think if you can marry that narrative of bad facts, which obviously you have to be factual in your responses to their questions, and you don't want to try to engage in spin and alienate them. You want them to trust you, but you marry that with a really strong narrative of what you've done to right the ship. And I think that goes a long way. And in my experience, in some of the cases where there have been, I think, the most distinct, stark facts that are the most troubling, we've emerged, my clients have emerged better, stronger, and really, I mean, in a resolution with the government that wasn't too painful, but I think it was all predicated on their compliance improvements and the remedial steps they took, and the way they approached the investigation, the way they cooperated. I think that means a lot.
So we're getting constant feedback on timing here. We have a clock that's going down second by second. So just to give you an idea where we're going, we've got about 13 and a half minutes left to this. And so I want to ask another question or two about this. And then we're going to cover a little bit about how you stop this crisis from occurring in the first place, compliance. That's obviously the ideal outcome. And then we'll save some time at the end for questions, so you could start thinking about some questions. So before we get to compliance, Glenn, let me ask you this. I've given an example where a grand jury subpoena triggers this crisis, but let's say there's some other avenues where it might happen, a whistleblower complaint or the media. I guess one question is, how might that be different or similar, and how do you address complaints that come from, or allegations or stories that come from these other sources as opposed to a grand jury subpoena where it's the government?
Yeah. We take every allegation of any nature comes in centralized to my group, and we take everyone very seriously. If we get and we look into everyone. If something is when you read a whistleblower email or complaint, you can kind of get a sense as to, just off the bat, as to whether it's kind of a ramble that looks like it's from a disgruntled employee. You're still going to take that very seriously, but it gives you a context as opposed to something with a grand jury subpoena, which obviously there's a lot of thought that goes into that. So you take it in context, but we look at everything carefully and seriously. A news article somewhere, I would say, in between those two things, because a news article, although there's a lot of ways that things hit Google these days, but for the internet these days, but for the most part, I'd put that somewhere in between. We take every allegation seriously, and frankly, something that's in the press or on the internet, something that's from a whistleblower where they happen to copy the board of directors and the CEO and signal that they may reach out to the SEC. In some ways, even if they may have less, they may ultimately be less of a big thing because they just, on their face, they don't seem like they may have as much of a real impact. We may take those as, if not more seriously, because there's more of a clock going on. There's now a media impact. The board of directors, we have to respond to them. We have to let them know what we're doing. We may need to let the SEC know what we're doing. So, long-winded way of saying we treat every matter that comes in the same internally. There's a context, but it's a context.
I just wanted to add to that. I think one thing that's really critical you touched on is learning or having the right professionals to separate wheat from chaff in that initial instant, because many times what seems like something small can become big. And we have U.S. attorneys' offices in this city, in our experience, that issue grand jury subpoenas when they read a news article. So they might read something that looks kind of interesting and they'll send their grand jury subpoena. And I think we all have to really also think about the Me Too movement. That is a compliance risk issue. And that's an issue that, at least from the clients I've spoken to recently, is at top of mind. And many times the government can reflect a culture that is problematic and maybe of more interest to them on other fronts. So I cannot emphasize enough how critical that issue is right now, and I think is on top of mind, and it presents a real corporate crisis risk issue and should be regarded in kind of the same light as a grand jury subpoena for investigating wire fraud. This is important stuff, I think.
And let's stick with that. Whether it's about the Me Too movement and those kinds of allegations and developments, or even corporate risk more broadly. So Steve, let's try to stop this crisis from happening in the first place. Let's try to make this panel moot. What do you do? We'll end it right now. What can you do?
Give back time.
What can you do to stop the crisis from happening? I mean, we've talked about what you do when you're under investigation, but how can you decrease the chances that the investigation happens at all, or decrease the risk that the crisis is brewing or bubbles up to you?
I think it's the last formulation of your question, which is the one I can answer. How to stop it? I mean, we have to be realistic. You can have the greatest compliance program. You can have excellent tone from the top. You can have, leadership that walks the walk, talks the talk, does everything right. But, for the reasons Katya mentioned, with the law of respondent superior, if you have an employee that does not follow the program, decides to commit a crime, understands what your compliance program is, and decides, I'm going to subvert it and I'm going to commit a crime, you can have an issue. So there's no way to stop it. The way to address it and mitigate the risk, right? It's all about how we mitigate risk is, the types of things people are talking about, sort of understanding what your risk is, thinking it constantly, talking about compliance, making sure that your compliance program is well funded, that it's staffed with professionals, that they have the resources that they need, that you have the right senior leadership that supports the culture and executes well on the program, that it's not static, it changes. What's a risk today is not necessarily a risk tomorrow, and whether that means, something more formal or just we see, increased media or a new priority that the regulators are looking at, is that something that we want to take a look at and see how we are with that, right? That sort of forward thinking and having it top of mind, I think is going to help you immensely. To really demonstrate, I mean, for me, right, it's a company. It's not an individual. But these are all intent-based crimes that companies get charged with. So if you ask me what is the intent of your company, look to its compliance program. Look to its people. Not the one person or the group of people that, despite the training, despite the clear culture, despite the program that's working 99.9% of the time, except for this one discrete issue, that is the corporate culture. That is the corporate intent. You're in a much better place of having a conversation with the government from the very beginning, as opposed to when the facts start to lay out. You can have those, they understand that sort of coming forward.
So Glenn and Claire, Katya, anybody want to add on this compliance point, whether to add things that you do similarly or differently, or how good compliance is advantageous when you're interacting with the government?
I'd like to jump in and to echo what Steve said. I think what's very, very important is that compliance isn't static. And to me, that's what's so important about conferences like this, when folks get together from different industries, from different companies, and compare notes. What are you doing? Is that working? And you get ideas, and you can change and you can adapt, both as the climate changes, the regulatory climate, the climate of what the government's interested in, as well as things like technology. I mean, the compliance culture today is very, very different than it was 10 years ago, and I'm sure it will be different 10 years from now. And taking advantage of those things, being proactive, having the resources in place, so when and if this big bad thing comes, you're ready, that's what you should be doing.
Glenn?
Agree completely. I would just add one additional thought, and it's a little bit of, the unknown unknowns. You can't measure what didn't happen, but I do think there are ways to prevent, things are always going to happen, of course, But I think it's cliche, but I think it's very true. Training and training tone for topic, we could have a whole day on that. But I do think, I'll give a quick example on training. We recently changed some of our training modules. We made it more targeted, shorter, more focused to really address certain risk at the company. A couple of months ago, we got a call from a person who basically self-reported. And they said, I was looking at this training, I was looking at our annual training, and it said this is an issue, and I think we've been doing it wrong, and I wanted to just check. They were doing it wrong. They were acting in good faith. We fixed it. It was not a big or medium, it was a small problem. But that made my day, made my week, because that's us preventing. I really do believe big problems really start as small problems. That was a small problem that we caught, and it could have easily become a huge, books and records, who knows? But it wasn't. So you don't know what you don't know, but I do think, obviously, and it goes to just the great compliance programs, there's a reason why these are best practices, because they do work, although even though they're hard to measure.
So I have one more question for the panel, and then we'll see if anyone has any out there. So Katya, ties together a little bit with what we've just been talking about, but the Department of Justice just issued a new policy, I think a few months ago, this month really, about, it's March, isn't it? About self-reporting and how the department is going to handle that. In some ways the same, in some ways different. Can you just tell us quickly what they said, essentially, and what it means?
So this originated in the fraud section, of which Glenn is an alum. It's the notion that you get credit if you self-report. So if you do get one of those, you get a call to your hotline and you investigate and you realize that there's been a crime and you think that it's actually something, you really have to balance your risks. If you think that it's something significant enough that a grand jury investigation could come down the road, you may decide to self-report. You may decide to walk into DOJ and tell them about the facts that you found. Obviously, that's a very difficult decision that has to be taken, on a case-by-case basis. Because if it is something that you don't think is going to turn into a big problem, and that's a tough decision, you may not self-report. You may just try to figure out what happened and remediate and move on. But DOJ has basically said that they're taking this FCPA guidance that was in existence and they're now going to apply it to all criminal investigations across the criminal division. And so what that means is that they've announced to corporate America that if you find a problem, it's a federal violation or feasibly a federal violation, if you walk into DOJ and tell them, you will get absolute credit at the end of the day when they decide what to do with you over the course of their investigation.
And to be very explicit, this means you walk in and you tell them something they have no idea happened, right?
Yeah.
That's what we're talking about. Okay. So let's see if there's any questions. We have a little bit of time. Yes. Right. Yes.
Thank you. The recent development that perhaps agency guidances would not be binding. And my question is about that, some insights, and particularly with respect to the Yates memo also. Thank you.
Yeah, well, interestingly, DOJ did say that, and then nonetheless, in a speech, the Deputy Attorney General, Rod Rosenstein, said this, what Katya just said, which, I don't know, it sounds like guidance to me, but so I think it's hard to tell. I don't know if anyone wants to sound in on that. Glenn, yeah, you're old
Right.
part of DOJ.
Old, so I'll say, yeah, it is hard to tell. I think it's fair. When the Deputy Attorney General speaks in front of an audience, I listen to that.
Yeah.
I don't, and I think that, candidly, I think there's a bit of confusion here. I will say just generally, when I read the Yates memo, and there's been a lot written and said about the Yates memo, I think every good, honest, hardworking prosecutor tries to bring cases against individuals. I think they always have, and they are, and they always will. So when I read I read the Yates memo a little more with a healthy skepticism, in that I thought this is what we did when I was a prosecutor. This is what they should be doing, and we're going to continue to do. So I understand they're trying to create some incentives, but I'm not seeing a huge change. But to Tony's point, there's a lot of tea leaves to read, and the best tea leaves are just kind of, just reading the papers and finding out the kind of cases they bring.
In some ways, they're codifying what we all knew already, right? I guess. Another question. We have time maybe for one or two more. I can't tell. Bright lights. Yes.
Question here. So recent Supreme Court decision, unanimous decision, that Dodd-Frank's anti-retaliation protection for whistleblowers does not extend to somebody who didn't go to the SEC. Would you all have us do anything different, though, in terms of running a compliance and ethics program? Some of us are in legal, and some of us are in compliance, and some of us are in both. So, but on the compliance and ethics side, should we do anything differently?
You were moving your mouth. So
No, I was swallowing. I think, look, it came out about 3 weeks ago. It just came out, so I think we're still all figuring out what that means. I think for companies, you just keep doing what we're doing. We take all whistleblower complaints very seriously. I'm interested to see if we get more of them, and I think that's where and if the SEC they're pretty transparent about their stats, not just resolutions, but intake. So I think it'll be interesting to see if they see an uptick. There's a concern that there may be an uptick just because instead of getting the letter to the company that suggests you may go to the SEC, then it just may copy the SEC. I just think it's too soon to tell, but I think in terms of my company, we read it, we're aware of it, we have a good way of dealing with whistleblowers, and we take all those allegations carefully and seriously and scope them, and we're going to continue to do that. I'm not sure it's going to have a huge impact.
Yeah, and to be clear, like whistleblower complaints, the message to your employees should be, if you see something, say something. It's not if you see a violation of law, right? That's not the standard. You may not be doing what's best for your clients, okay? That doesn't mean that you're not doing something in compliance with the law, but it's what your business principle is. So, it's something to watch. I think Glenn's right, but sort of, is it going to be a sea change in how companies address, the types of things that companies, good-minded companies, are asking their people and outside to raise if they see something? Probably not at the end of the day, but we'll see.
Okay. So the clock is now going up, so I think that means we're over as it counts. So thank you very much to our panelists. Thank you to all of you for coming and your good questions.